We are in open session, Mr. President.
Thank you. Please proceed.
Now, Mr. Witness, you recall, I was asking you the question that you recall that the host of what we had was castigating a caller, isn't it?
Yes, Your Honor.
And he was very specifically telling the caller that we should subscribe to party ideologies as opposed to an individual, isn't it?
Yes, Your Honor.
He also castigated the caller to the effect that you should not follow an individual blindly, isn't it, Mr. Witness?
Yes, Your Honor.
Mr. Witness, could you tell the court who the caller was referring to as the person that needs to be followed?
Mr. William Ruto.
And Mr. Witness, could you tell us from the totality of what you heard whether the host of the program was in support of the following of that Mr. Ruto that the caller had wanted to have supported?
It's difficult to answer this question in the sense that it takes a number of things. The surrounding, what was the issues at that time. When he's castigating violence, what was happening at that time. My understanding is that when he's saying, let's follow the party, I've got an understanding in the sense that Mr. William Ruto had already become popular. So there is this metamorphosis now, that now the next step is to look for a party where Mr. Ruto will join. So I think it should not be taken in isolation. It depends on many issues. But of course, he was not saying, let's follow Mr. Ruto.
Mr. Witness, does the host of the program recommend the following of any political party?
Come up again.
Mr. Witness, the host makes reference to PNU, doesn't he?
Yes.
He also makes reference to ODM, isn't it?
Yes.
He also makes reference to ODM Kenya, doesn't he?
Yes.
And at the end of having listed all those parties, does he recommend that any one of the three parties should be the preferred party for his listeners?
Not from what I've read.
Mr. Witness, I want you to look at the text that I just gave you, page 3, if you don't mind. If you could go to page 3.
I don't have the text.
Will the court officers kindly return the transcript to the witness? Mr. King Katwa, you said page 3.
Yes, Mr. President. Are you there, Mr. Witness, with a sentence starting with Sang? I am surprised.
Page
3.
Yes.
Mr. Witness, could you confirm that Mr. Sang says that I am shocked in the second line?
Yes.
Could you explain to the court, from what you heard in the audio and on the translation as made, what shocked him, in your own words?
The caller
No, Mr. Sang, who is expressing shock in this page.
is shocked by the fact that the caller don't prioritize the party, but the person.
And the person specifically is Mr. Ruto, isn't it?
Mr. Ruto.
Now, Mr. Witness, as at this date, we have all seen that it was 27 days to elections, isn't it, Mr. Witness?
Yes, Your Honor.
Mr. Witness, based on your knowledge, it is true that by that date, all candidates already were in the parties which they would use to contest the elections, isn't it?
Yes, Your Honor.
Including Mr. Ruto was already in a party, isn't it?
Yes, Your Honor.
Which party was Mr. Ruto?
That question is, okay, he was in Kanu at the same time, ODM.
Mr. Witness, you had some roles, or at least you witnessed the build-up to the elections and the period around the elections, isn't it?
Yes, Your Honor.
And so you would know in what party Mr. Ruto was contesting, isn't it?
Yes, Your Honor.
Based on that information, as opposed to what you think, what party was Mr. Ruto?
Mr. Ruto was to contest in ODM party.
Mr. Witness, lastly, I want to take you back to page 1 of that same document. Mr. Witness, are you there?
Yes, Your Honor.
You can see where it starts. Only 27 days can make you be so angry to the extent that you could be jailed for, or put you under the unpleasant circumstances. So let us persevere and know that we are all in Kenya. Can you see that, Mr. Witness? That's paragraph 3, Mr. Witness.
Page?
Page 1.
Yes. Only 27 days, yes.
Mr. Witness, you can see that this is what he says. Only 27 days can make you be so angry to the extent that you could be jailed or put you under other unpleasant circumstances. So let us persevere and know that we are all in Kenya. Can you see that, Mr. Witness?
Yes, Your Honor.
I want you to look at the last 3 lines of the same paragraph, starting with the words, so this is the time.
Yes.
Mr. Witness, confirm this is what Mr. Sang says. So this is the time to embrace that state of empathy, ignore other things, and save the country. Let us not be counted amongst those who destroy our country. Let us protect it. Can you see that, Mr. Witness?
Yes, Your Honor.
Mr. Witness, you will confirm, as a matter of fact, that Mr. Sang was pleading for peace and for the unity of the country as a Kenya.
Yes, Your Honor.
Mr. President, those are the questions I had in respect to this document, and I pray to produce both.
Okay, 1 second. Let us go briefly into private session for a quick minute to set the stage.
We are in open session, Your Honors.
Right, Mr. Ken, you
Your Honour, I'll be very brief, with your leave. We are fortunate, of course, to have professional judges, and that was clearly contemplated by the drafters of the Rome Statute when they clearly did not anticipate that the threshold for admissibility would be made unduly onerous or high. The whole principle of the ICC, the Rome Statute, detailed in Article 69.4 and also Rule 63.2, is that evidence that is relevant and probative should, we say, prima facie, be admitted, and the bench, in due course, can give it what weight it deems appropriate. Your Honour, of course, and drawing from jurisprudence from the ICTY and ICTR, to the extent that it's persuasive at all, there should be some indicia of reliability. Your Honour, as we say that in the circumstances of this case, where a witness has identified the voice of Mr. Sang, of course the bench can very properly and safely admit that exhibit. Of course, the prosecution in due course, who have been given, we've been told, the full taped extract, are free to get evidence to controvert it. And in due course, of course, it may well be that a party may seek to get additional evidence regarding chain of custody. Your Honour, I won't say more. We could look at the jurisprudence of the Special Court for Sierra Leone and the ICTI in more detail. But, Your Honour, as a worst-case scenario, a bench can always accept evidence and give an exhibit to evidence de bene esse, conditional admissibility, on the requirement that further evidence, for example, on chain of custody, may be adduced later. So, Your Honour, for any way you look at it, we say the evidence can be exhibited, it should be exhibited, and there's no reason why the bench should be deprived of evidence that they can examine in due course as the trial progresses. And, of course, at this stage, it would be unsafe, we say, to view items of evidence in isolation. And that's why the requirements or the touchstones of relevance and probative value are so important, particularly when we have the advantage of professional and experienced judges. Your Honour, those are my brief submissions on this issue.
Fair enough, Mr. Ken. Of course, yes, the judges can make their own assessment of this thing and strip out the prejudice from what's substantive. But we also have to keep in mind the matter of efficiency. The difficulty is to relax the rules to the point where everything comes in on the theory that there are professional judges who can make a distinction between wheat and chaff, as the case may be. But at the end of the day, if the record is so overwhelmed with chaff that it's difficult to get to the wheat, I don't see how that serves a purpose. We don't need to debate it. I'm simply saying it's a matter of we have to be careful with this thing.
Indeed, Mr. President, if it helps, and of course the statutory provisions are different in quite some ways, but just it may be of some persuasive value. The Special Court for Sierra Leone, as Mr. President, you're aware, in the Fofana and Kondewa case stated, and I quote, evidence is admissible once it is shown to be relevant. The question of its reliability is determined thereafter and is not a condition for its admissibility. And that's the AFRC case. Sorry, that's 21. That's the 11th of March 2005, paragraph 24 of the Fofana and Kondewa case, the CDF case. Your Honours, the ICTY has similar guidance that, and I quote, the threshold standard for the admission of evidence should not be set excessively high, as often documents are sought to be admitted into evidence, not as the ultimate proof of guilt or innocence.
Mr. Khan, that's not inconsistent with what
Indeed,
I had already said. I simply said we just need to be careful.
I'm obliged. Yes.
The chamber will rise for 5 minutes to consider this matter and we'll come back.
All rise, veuillez vous lever. All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir. We are in open session, Your Honors.
Thank you very much. It took longer than five minutes, but we have a ruling. The ruling is that the material will be marked for identification. The difficulty with it is that that problem of provenance and the difficulty of the witness not having listened to the entire tape and is not in a position to speak to the integrity of the audio. So it will be marked for identification. So you're not, defense, you're not being told you can never use it, but you know what to do to make it better. We'll leave it at that.
Thank you, Mr. President. The audio CAN D11 0013 0023 will bear the number MFI-T-D11-00012. The document CAN D11 0013 0024 will bear the number MFI-T-D11-00013. Both items will be registered as confidential.
Thank you very much. Mr. Katwa?
Mr. President, I would like to play an audio, and I'm moving into a different issue altogether. And Mr. President, the substance of what I want to go to is in tab 28.
We go into private session.
If the court officer could assist to pass on the bundle to the witness.
We are in open session, Mr. President.
Thank you. Mr. Katwa, please proceed.
Now, Mr. Witness, I want you to look at the document I've just given you. Could you confirm that you can see that it is 33 pages long?
Mine is 31 pages.
Okay, Mr. Witness, yours is 31 pages. That will still do for my question. Could you confirm that to the extent of what you can see, there are various people who called into the program?
Yes, Your Honor.
And Mr. Witness, could you confirm that the subject that Mr. Sang was inviting people to discuss was the question as to whether or not the violence was planned?
Yes, Your Honor.
Could you confirm that, secondly, the second thing that he was asking is whether or not there are people who are continuing to sponsor violence as is seen at line 619 to line 621?
Yes, Your Honor.
Mr. Witness, looking at line 631, could you confirm that Mr. Sang says whoever is maybe behind this organization is a member of a gang?
Yes, Your Honor.
Mr. Witness, you also noticed that Mr. Sang has highlighted the fact that the violence was all over the country, isn't it, Kenya?
Yes, Your Honor.
Mr. Witness, did you by any chance listen to this broadcast?
I can't remember.
And Mr. Witness, you would agree that if Mr. Sang was part of the people who planned this violence, he couldn't invite people to discuss it with the risk of him being disclosed, isn't it, Mr. Witness?
I object to that question, Your Honor. I don't think the witness can give a response to it.
Question is argumentative. Objection is sustained.
Mr. Witness, when the prosecution played out to you the audio that the prosecution showed you, which we now know is for the 18th of February 2008, did they play this audio to you simultaneously? Mr. Witness, you recall that there is an audio that the prosecution played out to you?
I recall.
You recall that we were able to establish that it was for 18th of February, isn't it?
Yes, Your Honor.
I am asking, when they played out that audio to you, did they also play out this audio?
Did they play out this audio? This one?
Yes, Mr. Witness. The one I've just played out to you and the one we are looking at the translation. Mr. Witness, do you want me to ask again?
The issue is...
My question is fairly simple and straight, Mr. Witness.
No, I can't remember.
No,
Mr. Kigen-Katwa, why don't you repeat the question?
Mr. Witness, you recall the audio I just told you was played out to you by the prosecution. You recall that, isn't it?
Yes, Your Honor.
Just a moment ago, I also played out an audio to you. You recall that, isn't it?
Yes, Your Honor.
Do you recall the prosecution having given you an opportunity to listen to the same audio that I've just played now?
No, I don't recall.
Now, Mr. Witness, you realize that Mr. Sang is asking the audience, the listenership, in his Lene Emet program to call in and tell and disclose if anybody planned or sponsored the violence. You see that, Mr. Witness?
Yes, Your Honor.
Your Honor, that should be the extent of the questions I have in respect to this document, except that I would want to put on record what is contained at line 603 to line 636. I am prepared to read it, but probably the court would prefer that it be done in private session.
No, right. Let's go into private session then.